Tonight on that front, we unpack for you the recent Court of Appeal decision in the high-profile ambulance scandal case. The court has ruled that KCL Atufosin and Raymond Acquah have no case to answer, acquitting and discharging the two. A verdict that has stirred significant controversy, with the Attorney General of the Republic of Ghana, Godfrey Yeboah-Dame, announcing plans to appeal the decision and also labeling it as perverse and against the weight of evidence. Joining me tonight on this show is the former director of the Ghana School of Law, Kweku Ansah Asare. We shall also be joined by others in our quest to explore exactly what is in this judgment. What does it mean? And we try to unpack these developments, providing in-depth analysis and expert opinions on what the ruling means for public accountability and the rule of law in the Republic of Ghana. I understand that Mr. Ansah Asare is already joined us now. Later on, we'll be having a broader conversation with those who are already raising concerns about what the other impact of this ruling is supposed to be. Now, we should be now having a conversation with the former director of the Ghana School of Law. Mr. Ansah Asare, you're welcome to our front.
Thanks for having me on your show.
Let's start to the layperson. Let's start with an understanding of why was there a decision at the Court of Appeal when we were all following the case in the High Court?
Well, midway through the trial at the High Court, at the end of the prosecution's case, the counsel for A1, that's the first accused and the third accused, made a submission of no case. A submission of no case simply means that at the end of the prosecution's case, they had not been able to make any connection or link the persons accused to the offense charge. And therefore, there's nothing for them to say in their defense. So since nothing has been leveled, so to speak, against them at that stage. Now, under our criminal justice system, at the end of the prosecution's case, the accused person has one of two things to do. The accused person may simply open his defense, that where the prosecution has finished. So let me take my turn and respond. Or the accused person may say that, but all that you have said does not, in any way affect me, and therefore, I should not be called upon to open my defense in an attempt to, respond or react to all that, you have said. Therefore, at the end of the prosecution case in the Acquah case, what Atufosin and Acquah said was that, their guilt has not been established at that first stage. So no prima facie case had been made against them. And therefore, the trial judge had erred in asking them to open their defense because there was nothing for them to react to at the end of the prosecution's case.
If one peruses this 125 or so page judgment by the Court of Appeal, something stands out. Justice Akah-Boafo said they were appealing on 8 grounds. He said the first 6 or some of the 8 were not things he was going to deal with and that they were not competent, and rested on 2 out of the 8. He then proceeded to explore these 2, giving an understanding of what the background is supposed to be. Please, let us understand what these grounds mean. I just heard you say that they said they had no case to answer. But what was exactly their reasoning for saying they had no case to answer?
Yes, 3 justices constituted the panel. Now, out of the 3, 2 said that the accused persons should not be called upon to open their defense because the prosecution was not able to establish the necessary legal nexus or link or connection between the allegations and the person before the court. Now, the two who returned who upheld the submission of no case, that's Boafo and Bryce Mensah, they were clear in their minds. One of them, Boafo, indicated that he could not find any link between the charges and the person. That's what he said. He said he couldn't find any striking link. Then Justice Mensah, who concurred with him, said he wondered why Dr. Atuforsen was on trial in the first place, since the ambulance deal was primarily within the exclusive preserve of the Ministry of Health. And then the third, Justice Poku Echampong, he said, the prosecution had been able to make a prima facie case, that is, link the two to the offenses, brought against them. Now, at that stage, because the two were in the majority, they will carry the day, and that's how come they acquitted and discharged the accused persons. If they had simply acquitted without discharging them, they could have been rearrested within the precincts or premises of the court, to come back and face the charges. But they freed them. Go and say no more. So that was the end. Now, the Court of Appeal is immediately beneath or below the Supreme Court. And therefore, the fact that by a bare majority of 2-1, they had been acquitted and discharged does not mean that is a total or absolute, freedom or acquittal, because there is still a window of opportunity for the prosecution to, go to the upper terrace, that is the Supreme Court, to consider whether the two wise men were right or correct in their convictions, or whether the minority view should be upheld, in which case the Supreme Court will reverse the Court of Appeal decision. So the last word is yet to come.
Now, that is what we have heard from the Attorney General, and that's something that in the course of this conversation, I should be able to get a better and a proper understanding from you, sir. In paragraph 23, the court noted something and said that the trial judge discussed cases, including Republic versus Ibrahim Adam and others, in which Afred JSC, as he then was, set out the essential elements of the offense of causing financial loss to the state under Section 179A, and mentioned those things you lawyers call elements. That is, there should be financial loss. This loss should be caused to the state, caused through the action or omission of the accused, intended or desired to cause loss, or foresaw the loss as a virtual setting and took an unreasonable risk of it, or foresaw the loss as a probable consequence of his act and took an unreasonable risk of it, or if he had used reasonable caution and observation, it would have appeared to him that his act will probably cause or contribute to the loss. This is the definition of the charge that was labeled against Cassiel Atuforsen and Richard Japa in this particular case. I would appreciate it if you can break this thing down to the appreciation of a lay person. What does it mean? Do I have to steal or take monies? Of course, we've been hearing that there was some loss of some 3.7 or something beyond 3 million euros in the procurement of ambulances found later on, as the Attorney General says, to be defective. What are we accusing them of doing wrong?
That is the big question. Now, you see, this whole thing started on the footing of a contract between the government of Ghana and the sellers, the suppliers of the ambulance.
Big C.
So it was a contract between the government acting by the Ministry of Health and not the Ministry of Finance. Now, the Ministry of Finance has a correlation, with the whole transaction because it is the ministry, that would give approval for the establishment of the letters of credit because it wasn't, a straight buy and sell cash down. It was, through or via establishment of letters of credit. I don't have the money now, but somebody will guarantee the payment if you supply. So, JAPA, the third accused person, or the vehicular means through which that deal was cemented. Now, the role that Dr. Atufosin is alleged to have played was simply, giving approval, that it should be done. Nothing, so far about the Ministry of Health and the others. Now, this is also traceable to the State of Nation address that the late Professor Mills delivered. So one will have, to go through all that in order to establish the essential ingredients or elements of the crime, to the accused person. In the minds of the majority, that is Akabuafo and Justice Bright Mensah, they said that they could not link the issue of the establishment of the letters of credit to the willful, desire to cause financial loss. We are talking of 10 ambulances that were found to be defective and others not having certain things. What about, the rest? And then we are also told, that there had been an attempt to refund what was alleged, to be the subject matter of the trial, and the state refused. Now, if I am accused of something and the law allows reparation, and one says, look, if it is only causing financial loss, then here's your money. Now, as between the person who was willing to retire the alleged funds and the person who refused, who has caused the financial loss, this, will be the question that will be exercising the mind, of the judges, and it will create a doubt. Once that doubt is created in the mind of the tribunal or the justices, the accused persons will have, to be freed, because it would then mean the prosecution had not been able to establish a prima facie case. So on the face of it, they have not, they have been wrongfully accused of causing financial loss. If you look at, the fact and analyze them, the way I've done, I am prepared to refund. Say, you won't accept.
On the point of refunding or paying back the money, I've heard the Attorney General say that this request came from Big C, and Big C was even though the contracting party with the Ministry of Health, Big C was not a party to the case in court. So they did not understand how, and he felt it would have been improper for somebody who is not a party to the case in court to offer to pay back monies it had received for the supply of these, in his words, defective ambulances. Is that a reasonable response? No,
because there is what is known as privity of contract. Therefore, if the element of privity can be established between the two of them. Then, why deny? So I am going to supply. I am, paying you. There's a third party. A third party, can do what they wanted to do. So at first sight, I didn't understand, why we refused the money, we refused the repayment or the retirement, but then went after, the person. At the end of the day, even if, the state secured a conviction and they had repented and therefore they have refunded the money, would you still put them in? So as between the person who insisted on this trial, that person has rather called a financial loss to the state because it was utterly unnecessary. The trial was utterly unnecessary, given the fact in front of us now.
But with respect, the Attorney General has reiterated the relevant facts of this matter. Are you saying that vehicles purporting to be ambulances were not imported into the country in December 2014? And this is what the Attorney General says was in violation of the contract governing the transaction. The Attorney General has also explained that the then Minister for Health, Sherry Aite, had cautioned in writing against the importation of the vehicles into the country and further indicated that there was thus no request by the Ministry of Health for the vehicles to be imported into the country or for the letters of credit which were the means of payment for the vehicles under the contract to be established. And I'm reading directly from the statement that the Attorney General issued. Is it to your mind that these things did not happen? Because you say that this whole proceeding in court was unnecessary in the first place.
Yes, and I still stand by what I said. The fact is that the scenarios, presented in this case are contradictory. In one breath, you see that there was an attempt to do this. In another breath, they will deny. And yet in another breath, they will say that the Attorney General said. Now, in a country where you have, these things happening, as we speak now, there have been many contracts that the state claims, to have entered into. Payments have been made, there are no work done. So this is a culture that has been going on. My point is, they were prepared to, or a company, a third party was prepared to reimburse, the state of whatever loss. So once that, reimbursement is accepted, the total financial loss is erased. It will no longer, be there. So why did the state choose not to, accept? We rejected, that offer. So it's no longer available. But still, they want to pay. You see, and if, for instance, it comes out that finally that both the trial judge and the minority were wrong, are we going to compensate Acquah and the others supporting the Supreme Court? Because the Supreme Court has got the power to order compensation for the two of them. But on public policy grounds, this is one of the cases that shouldn't even attract the view that I'm subscribing at the moment. That they've done the wrong thing, and we are going to compensate them. So that one should not even be on the table. Having said that, I will maintain my stance that the trial should not have taken place, given the fact, if it is true that there was an attempt to refund the entire amount and it was rejected. That's where I'm coming from.
I get your point. Now, in the judgment, in paragraph 79 and 79, I suspect, it was stated that Mr. Edumazi-Mensah, in his testimony, affirmed that in all situations, the Ministry of Finance authorizes and approves public financing of ministries and, in effect, government departments. To that extent, It is my view, this is Justice Akabuafo speaking, that requesting the issuance of an LC on behalf of the Ministry of Health was not out of place by the first appellant as a deputy finance minister. We are talking here about Atuforsen. This was done after the AG had received a notice of intention to sue for breach of contract by Big C and advised the Ministry of Health of the consequences of non-compliance. Again, he proceeds, it is trite that in the context of performing official public acts, there is a presumption of regularity until the contrary is proved. What does this really mean?
Okay, so what it really means, is that as far as the tribunal of fact, that's the court, is concerned, they went by the element the law requires, to prove or establish guilt in such cases. Now, you omitted one good thing that Justice Akabuafo, in saying paragraph 79, where he said that there was no link between the evidence adduced by the prosecution and the offense the prosecution claimed to have been committed. And then he continued to say, quote, I'm of the view that the prosecution failed to provide sufficient evidence that meets the threshold of connecting first appellant, that is Dr. Atuforsen, with the offenses he's charged with. After that, then he proceeded to say that this whole business, was one based on establishment of letters of credit. That was the Minister of Health that had set the ball rolling, and Atuforsen's involvement was merely to give approval. So it is an administrative act, if I understand what the judge wanted to say. It was an administrative act that, he executed, and therefore he should not be held, culpably responsible for merely discharging an administrative function.
Okay, now
that's how I'm understanding. And then on his part, Justice Mensah, said that apart from Atuforsen writing to the Bank of Ghana for the letters of credit for the purchase of the ambulances, Dr. Atuforsen played no significant role for him to be held accountable and subsequently directed to open his defense. Now, one can, cavil at these two opinions and say that, well, in that case, let us go upstairs, to test the correctness of the opinions that these two justices who return the bare majority verdict, hold, or the view they share. It is most likely that another tribunal of fact will just focus on the fact of the establishment of the letters of credit, regardless of the precise rules with exactitude of what Dr. Atuforsen or Jacques played. But then the actual culprit, the Ministry of Finance, will have something on which to write, free. They belatedly decided, to disengage from the whole contract. That our attention has been drawn to the fact that there's something untoward in the whole business, and therefore we'll call the deal off. If a tribunal of fact should rest its opinion on this, I'll go along with that. That then the Ministry of Health ought not to be invited. In that case, then the entire thing will be, on the head of Dr. Atuforsen. But if he was merely a conduit to sign and give approval, then it was an administrative action. Somebody must approve, and he approved.
But there's also this reference to Sektekpe as minister, with a claim that he should have been part of the conversation from the beginning, and that the prosecution should have actually invited him to come and give testimony in dealing with the matter of whether or not Atuforsen had authorization to issue that particular letter demanding the letters of credit.
Yeah, but that will flow from, memoranda, exchange between the minister and his deputy, or between the deputy and the chief director. In all these, matters, they will have their authority, will derive, from what the act establishing the Ministry of Finance says. So if the minister, authorizes the deputy to do it, and the deputy has done it, then you can choose between the substantive minister and the person who signed. And the prosecution chose to go after Dr. Atuforsen. And for me, excluding or leaving out Tekpe was, a break in the chain. Because if the prosecution needed to succeed at all, then they ought to have made sure that there will be no break in the chain. Now, once the link or the connection, is faulted, it's like, leaving a vital evidence out. And if the vital evidence, is out, your case, becomes flawed, which is what has happened.
In a sum, there are those who have already started saying this judgment means that you can do anything you want in public office and get away with it. Is that a true reflection of what is in the 125
No,
pages?
I don't think so. I don't think so. There are certain the good things about this, judgment. First of all, we should all, keep in view the fact that the Court of Appeal decision is not a final pronouncement on this matter. The only body, the only entity that has the last word is the Supreme Court. However, as I said, there is this, small window of opportunity for the prosecution, to go for a reversal, the Supreme Court, if they do, their homework well. But I'm not suggesting that they win. My view is that the reasoning of the bare majority, or the 2-1, is sound. What they are saying is that, at the end of the prosecution's case, there was neither a tittle or shred of evidence to warrant the accused person to open, their case. For me, it marks a step in the fight towards a strong judiciary that we have been advocating for. It is not something, that we should reasonably hope that will continue, forever. But at least it's a good start. Let's also recall the president's, work when he was swearing in the 16 justices who have been elevated to the Court of Appeal. He admonished them to be fearless, courageous, bold, and apply, the law to the fact, which is what I see has been done in this case. Now, if the prosecution desires to test this verdict on appeal, I will humbly, pray to the Attorney General and his deputies not to be opening their mouths too wide, and expect to jubilate after the Supreme Court has spoken. Once they do that, they are sending the wrong signals that, yes, we are going to where we know we will win by all means. It's not, something that we should encourage. But if they do test the correctness of the verdict on appeal and they succeed, then I will expect, like the Court of Appeal did, each Supreme Court judge to deliver his or her own opinion, rather than one person, speaking, so that each time the Supreme Court speaks by one voice, it is unanimous, and then the newspapers, the Supreme Court bounces at 7-0. That's the kind of culture that we should discourage from happening, and it was unfortunate that soon after the verdict, the Attorney General opened his mouth and said he will appeal. Then the deputy said the minority. Mind you, the minority are debating. So we also go there, and then when we get a verdict, we also debate. Turning the Supreme Court, into a football ground, fun-making, merry-making thing. The Supreme Court is a very serious venue for serious legal business. It's not for fun-making. It is not a venue that, people should go, lawyers should go and expect, to be doing jomborijo there. No. That once the Supreme Court decides, and we should all remember that the Supreme Court has the final say in all legal matters, according to Article 129, Clause 3, the 1992 Constitution. So, yes, they can, go on appeal, but no to the way and manner, in which they communicate, the route towards appeal.
Now, talking about the conduct of the Attorney General, he had himself on this network described the judgment as perverse. He had other words that the Ghana Bar Association was not happy with. He says that this, if allowed to stand, would actually promote impunity, abuse of office, and all the related words to that. And he believes that the judgment is against the weight of evidence applied. Are you on the side or in support of his right to free speech and his right to insist on describing a judgment he disagrees with in his own words?
Oh, why not? He can. He has the freedom. Nothing stops him, from being, from saying anything. Just that he could be measured, in the description, the word uses and others. But you see, it lies ill in his mouth, to make any such allegations in the first place. Here is an Attorney General who has himself subverted the Constitution and the rule of law by coaching an accused person to lie, in court. And he is saying that people are getting away largely with impunity. He's gotten away largely with impunity by refusing to step down. Elsewhere, he will be arraigned. He'll be charged, with offense of witness tampering and be made to face the law. Now, if at the end of the prosecution's case, the Court of Appeal, has expressed a certain, dissatisfaction with the procedure, i.e., the fact that the trial judge herself, an appellate judge, the fact that the trial judge, had, ordered or ruled that the A1 and A3 should be made to open their defense. I don't see anything wrong with it. They went on appeal. You remember, I was interviewed. I granted you an interview, and I said, if they were going to go on appeal. Now, they've gone on appeal. Whether it had a, dim, chance or a bright chance was neither for me, or for you to say. The people, who have the most say in it have voted. And they are saying that the students have been, asked to open their defense. If the Attorney General, felt strongly that it was wrong, well, the door, the Court of Appeal judges left the key hanging at the top. You can look up there. You find the key, go and open the Supreme Court, they enter. And then, but to say that the judge had done this, the judges, as if, he was lambasting them. He should lambast himself, first of all, for doing the untoward. When we law teachers are teaching, we often draw inferences from, cases such as, the instance one that discussing. And then we also discuss the role that the actors play, the Attorney General, the prosecutors, the defense, accused persons, and all that. Now, if I teach my students and tell them that the Attorney General's conduct was, very reprehensible. And yet, the next day, I entered the lecture hall and tell my student that the same Attorney General is now speaking. Do you think that the public will continue to have confidence in the machinery of justice? They will not. They will not. And therefore, he should be the last person to castigate anybody for, doing things, and getting away largely with impunity. He has shown the way. I'll not spare him at all. Because what he has done, if we were in a society that respects the rule of law, he would have been made to face the full rigor of the law. He has been allowed, this opportunity, because the person who appointed him doesn't see anything wrong with, what he has done. And I didn't appoint him. So I can snarl, I can swear, I can say anything. It will not make any difference to his position. It is only His Excellency the President whose work can make, all the difference that, majority of Ghanaians desire in this matter. For my part, I'm saying that the way the Attorney General conducted himself in this case was so shameful and disgraceful that at the end of the day, he should not be seen or be heard, to be expressing any dissatisfaction with the way and manner the case was conducted.
Now, I get that. Should he take back those words?
I don't think that, he will redeem himself, by withdrawing those words. He will not. Mind you, most of our ministers are very arrogant, and he's one of them. He is not going to withdraw their words. We find it difficult to say sorry. You see, now that's why I said I'm pleading with them not to open their mouths anymore. They should allow the state attorneys and the chief state attorneys and principal state attorneys to say these things, and then you say, it wasn't the Attorney General, it was, one. But they themselves, you want to go to the Supreme Court in the reasonable expectation that the Supreme Court will reverse, the Court of Appeal decision, and then, you begin to dance from the premises of the Supreme Court. The Supreme Court is not a...
I am grateful to you for your time this evening. And if you have any last words, we will hear it now on how this case has panned from the, what they call Court of First Instance through to the Appeals Court, the Court of Appeal in this particular case.
And it's most likely to travel to the Supreme Court.
Certainly, I will be hearing more from you, sir. I am grateful to you. Kwaku Asansare is a former director of the Ghana School of Law. He is a lawyer, he's a law lecturer, and has been doing this for a pretty longer period than most people in this republic will know. After this break, we'll be hearing from the NPP's Raymond Acquah, who has some words of advice for the NDC. Welcome back to UPFront. Tonight, we'll be having a breakdown of what really this 125-page ruling from the Supreme Court really was about. And that conversation is with the former director of the Ghana School of Law. You just heard that. Now, let's expand the conversation to the follow-ups and the latest developments coming out. Of course, we know that the AG has been defending the position and insisting that they are going to actually appeal this. We've also heard or seen other summaries that you certainly should know about. One of them coming from the ever-distinguished Kwaku Asare. And maybe you should understand this. Let me just give you that brief he gave to. He says here, the court concludes that no reasonable court focused on justice would have found that the defendants had a case to answer. 2, the contract in question is between the Ministry of Health and Blue Seas. 3, the Ministry of Finance merely facilitates the contract by authorizing the letters of credit or letter of credit and does not become a party to the contract by doing so. This is the summary of Professor Kwaku Asare. And he says, nor does the Ministry of Finance assume any responsibility for the quality of goods delivered or ordered. And if the delivered goods are non-conforming, it is the responsibility of the Ministry of Health to exercise its contractual remedies. Failure to do so, potentially causing loss to the state, places the criminal burden solely on the Ministry of Health and not on the Ministry of Finance for authorizing the letter of credit. The Ministry of Health has a contractual duty to mitigate damages. This is important when the contract morphs into a criminal arena and issues arise about financial loss. This is what he says was also in the judgment. He says here, if a deputy minister signs a letter of credit on behalf of the minister and the minister does not contest this delegation of authority, it is unreasonable to assert that the deputy had no authority. If the prosecution claimed that the deputy lacked authority, the negative framing cannot shift the burden onto the deputy to prove his authority. The theory that it does is perverse. It's always the burden of the prosecution to prove what it alleges, and continues to say the agent of Blue Seas cannot bind the state. He was compensated by his principal following a court order. It is perplexing that the agent faces charges of woefully causing financial loss to the state, especially when the basis of his being asked to open his defense differs from the original charges. So in summary, this is what Professor Kwaku Asare put together. One more reaction that's been coming up following this development is that of the national organizer of the NPP, Raymond Acquah. He wrote, now, suddenly, John Mahama and the NDC are singing the praises of the judiciary they have bastardized and maligned for several years. Suddenly, the rule of law is at work because they have won. Suddenly, the court is no longer an appendage of government. Suddenly, the judges appointed by Akufo-Addo are not partisan. Raymond Acquah continues to say, the double standards of the NDC is regrettable and does not bode well for our democracy. While the Attorney General disagree with the decision of the court, we accept it in good faith and hope Mr. Mahama and the NDC do not change their course should the decision of the Court of Appeal be reversed by the Supreme Court. Luckily, he joins me now on the phone lines to give us some clarity on this particular matter. Raymond Acquah, you're welcome to our front.
Thank you very much, Raymond.
Yes, I've heard John Dramani Mahama congratulate the courts and also express some excitement about this particular ruling. I've also heard many in the NDC do so. So what is the premise of saying the party has a penchant for calling the judiciary an appendage of the government and that they should not change their language along the line?
Raymond, thank you. Good evening to your viewers and then your listeners. The joy and the merrymaking of the NDC and former President Mahama possibly could be short-lived. And I think that it is important that once they were not happy with a particular ruling, and then they proceeded to the Court of Appeal, they should know that this matter certainly will also appear before the Supreme Court. And when the decision of the Court of Appeal is overturned, that will not be a platform or that will not be a situation where the NDC and former President Mahama again will turn their guns on the judiciary, because former President Mahama has the penchant of, bastardizing, maligning. And sometimes the judiciary, and sometimes it's quite worrying. I mean, he's taken this to even to the international platform, where he was invited to speak, I think, in a particular university outside, and then he took the opportunity to again bastardize our judiciary. I think that on the globe, our judiciary is one of the best, and I think that we need to rather encourage them to do more work, and they've really helped our democracy a lot. Yes, I disagree totally with the decision of the Court of Appeal. I've read it. Look, for somebody to approve letters of credit or initiate letters of credit, not only that, and the person calls Comptroller and Accountant General make this payment on behalf of Ministry of Health, whilst Ministry of Health did not even make a request for that particular payment and that letters of credit. In fact, while Ministry of Health at the point, they were rather criticizing the ambulances that were brought into this country. In fact, Honorable former Minister of Health, may her soul rest in peace, Shaliaite, and then is on record, right, to have expressed their opposition to all of these arrangements. So if the former deputy minister, now majority leader Ato Forsen, was heavily involved in this matter, he approved of all of these letters of credit. The point where he could even call Attorney General to even effect payment for the charges involved in these letters of credit. He cannot be absolved from wrongdoing. And it can never be said that because the contract was between Ministry of Health and that of Deep Sea, you cannot in any way drag a minister who uses his portfolio, his office, to effect payment or to initiate letters of credit on behalf of the suppliers. I cannot in any way agree with the Court of Appeal. For me, the prosecution has already closed their case.
But do you think that decision is perverse? Do you also think it actually goes against...
It is very unfair, and it's very, very, very unfair to us, the public, to the public purse, because for me, he has a case to answer. In fact, this whole matter came about when the prosecution had finished their case, they had closed their case, they called all their witnesses, and then it was time for Honorable Ato Forsen to also open his case. That was when he filed for submission of no case. And then the trial judge said, no, you have a case to answer. The Attorney General has been able to establish a prima facie case against you. You have to answer. So I'll be surprised that in the face of all of these evidence put before the Court of Appeal will say that Ato Forsen has nothing, absolutely nothing to answer. What is this same person who authorized payment?
I get you.
I find it very weird.
Are you by this saying that the NPP party is throwing its weight behind the Attorney General in his quest to take it further to the Supreme Court?
Oh, certainly. We are not happy with the decision. For me, I think that it is a very poor decision to overturn the ruling of the High Court.
You've used
that is
words
why the
like
Attorney General
unfair.
had already signaled that it will be proceeding to the Supreme Court. I think that is the way to go.
You've used words like unfair. You've also said it's a poor one, but you've not said it's perverse. You've not said it goes against and promotes impunity. Those are words the Attorney General has used. The Ghana Bar Association.
It's the same thing. It's poor. I disagree with it. It's the same thing. I subscribe totally with whatever the Attorney General put on paper. I subscribe fully to that.
But the Ghana Bar Association says that those words were unnecessary.
Oh, I think that I disagree with them. If you have followed this case very well, I would be surprised that anybody will say Ato Forsen has absolutely nothing to answer. I will be very much surprised. No.
Now, the other issue that's also come up is whether or not by the very proceeding to the Supreme Court, we are not putting them in a tight corner. Do you think, and you use the expression when and not if the Supreme Court rules or reverses the decision, you are very convinced this would happen, aren't you?
Oh, yes, obviously. If you go to the court and then you believe so much in your case, you have to believe in it. But then certainly the decision will lie in the bosom of the Supreme Court. And when that day comes, all of us will be there to witness it. But for me, I think that I totally disagree with the decision. The rationale behind it for me is poor. And I'm in fact, I was scandalized. I was very surprised to see the rationale behind the decision. For me, I mean, I think it is a poor one, and I am very much convinced that if this should appear before the Supreme Court, it will be overturned.
Yes, just one point before we wrap up this conversation. Exactly what is in the reasoning, is it Justice Bright Mensah or Justice Acquah Boafo, that you find not in good taste? The rationale you talk about in the 125-page document.
No, to be
specifically where
the basic
you have
point.
a
The basic point. I mean,
as a lawyer,
not even go deep. The basic point is that the effect of the decision is that Atuforsen has absolutely nothing to answer, and for that matter, he's acquitted and discharged. That is the effect of it. That is why I'm saying that I disagree. I mean, how can anybody say that somebody who authorizes payment, somebody who effects the processes for letters of credit, somebody who authorizes a control and accountant general to pay for the charges involved in these letters of credit, how can you say that that person is absolved from any wrongdoing simply because the person was not a party to the contract? But that person was the deputy finance minister who got himself involved in the payment. And that is exactly what we are talking about.
Except that, the judgments indicate that beyond issuing the letter for the letters of credit, he took no further steps in that direction.
So that is why even that particular reason should have been the reason why he has a case to answer. That alone should have been the reason why he has a case to answer. So answer.
I get you, and I understand your point. Many thanks to you for joining us tonight. Raymond Acquah is the national organizer of the NPP, taking on the NDC in a statement asking them not to be selective when it comes to judgments. This matter will be explored further subsequently, but many thanks to you also for joining today's edition of UPFront. Many thanks to you, lawyer Kweku Ansah Asare. I appreciate you joining our show today.